Διεθνούς Δικαίου του Πανεπιστημίου Παρισίων. Είναι πρώην πρόεδρος της Επιτροπής Διεθνούς Δικαίου Ηνωμένων Εθνών και είναι μέλος της Επιτροπής. Είναι λέκτορας σε διάφορα πανεπιστήμια και διάφορα κέντρα διεθνών νομικών σπουδών διεθνώς. Είναι επίσης λέκτορας στο Πανεπιστήμιο, στο Yale Law School από το 2010. Αλλά μια πολύ σημαντική προσφορά του κυρίου Πελέ είναι οι 45 υποθέσεις που νομίζω είναι ρεκόρ που έχει αναλάβει ενώπιον του Διεθνούς Δικαστηρίου των Ηνωμένων Εθνών. Έχει αντιπροσωπεύσει την Ιαπωνία το 2010. Έχει αντιπροσωπεύσει την Ελλάδα από το 1995 μέχρι το 2008 σε διάφορες υποθέσεις. Έχει αντιπροσωπεύσει την Ρωσική Ομοσπονδία και πλήστες άλλες χώρες σε 45 υποθέσεις. Λοιπόν, αυτός ο διακεκριμένος καθηγητής και νομικός σύμβουλος είναι σήμερα μαζί μας και έχουμε την τιμή να ακούσουμε τη γνώμη του για το θέμα των Βρετανικών Βάσεων. Τον καλό στο βήμα.
Thank you very much. The honor is mine. Mr. Attorney General, Mr. Ministers, members of Parliament, Excellencies, ladies and gentlemen, dear friends. My companionship with Cyprus is an old story. It began years ago when Alain Pellet asked me to participate in several workshops relating to the international legal issues linked to the Turkish invasion of the actions of Cyprus in the European Court of Human Rights. Later, but more than 7 years ago, I think, Konstantinos Lykourgos asked several personal or collective legal opinions for the Attorney General of the Republic. And about at the same time, my good and respected friend, Judge Lukis Lukaides, was good enough to invite me to participate in to several sessions of the most stimulating series of lectures on human rights he used to organize. And more recently, I've been contacted by an illustrious citizen of this country, Minister Lilikas, whom, however, I had never met before. He had sent a mail to very kindly invite me to give this lecture, an offer which I accepted heartily, and I indulged myself to suggest some kind of reciprocity. And to my surprise, he's quite an important and busy man, but to my surprise, he generously accepted to lecture my postgraduate students in the University de Nanterre, and I would hope, but probably not expect, that you will be as interested in my presentation as my postgraduate students were by Yorgos Lilikas' lectures. Then, very spontaneously, we have become friends. Now, Minister Lilikas, can I raise this? No. Now, Minister Lilikas has not left me any choice regarding the subject matter of this lecture. It had to be on the so-called British sovereign basis. But it was understood between him and I that I would expose my own views in all freedom. It might have been, I must say, quite imprudent. After all, this is quite a controversial matter and rather sensitive matter in this country. Well, these are the risks of the academic freedom, and I congratulate you to have taken them. Now, I suspect that I tend to share what probably is a dominant view in the Republic. The British bases are not sovereign. They are an anomalous remnant from the colonial past. But you will probably note some nuances compared to what has been said by the two previous speakers. Three brief caveats before going to the heart of the matter. First, as you have noted, I will speak English, at least in my rather odd and particular English. I would certainly have preferred to the Aeschylus language, but unfortunately I don't speak Greek, and I'm afraid that the ancient Greek that I learned at school is not of great help to discussing sovereign basis arrays. And Yorgos Lilikas and myself thought that it might be preferable to use the actual lingua franca before the time of Chinese comes, than the now more provincial language of Molière or de Gaulle. Second, even though I am conscious that my topic has a heavy political and emotional charge in this country, I will exclusively place myself from the point of view of law, and more precisely of public international. Better than English, internationally the only language I really know, I can really speak. And I have to say also that I am not a EU lawyer, and that I might miss some aspects of recent developments of my topic in European law. And third caveat, and last warning, I have yielded to my friend Yorgos' request to speak on this sensitive topic, but I'm also conscious that I probably am in the room, in this room, the one who is less knowledgeable about this issue, and that you will probably think that I will more often than not state what you deem to be the obvious and line up commonplaces. My excuse might be that I have no message, I have no political position in this matter. I have thought about this all without any preconceived ideas, and all I will say now is genuine. It goes without saying that my purpose is not to describe the history or the legal status of the British bases in Cyprus as such, although I have tried to understand both when preparing this modest presentation. Let me, however, explain what I have precisely in mind when I name the British military bases in Cyprus. I would speak of BMBCs or BMBs in the rest of my speech, when I will try to reflect the British views. In that case, I will mention the SBAs. As indicated, as early as Article 1 of the Treaty of Establishment, the BMBCs are what the signatories called the Acroteries Sovereign Base Area and the Decalia Sovereign Base Area, which are formally subtracted from the sovereignty of the Republic of Cyprus, and, quote, shall remain, please note the wording, remain, I will come back to this, shall remain under the sovereignty of the United Kingdom, end of quote. And in Article 3 of the Treaty of Guarantee, the Republic of Cyprus, Greece and Turkey declare that they, quote again, undertake to respect the integrity of the areas retained under United Kingdom sovereignty at the time of the establishment of the Republic of Cyprus, and guarantee the use and enjoyment by the United Kingdom of the rights to be secured to it by the Republic of Cyprus in accordance with the treaty concerning the establishment of the Republic of Cyprus, signed at Nicosia on today's date, end of quote. The precise status of the SBAs, and it is in effect quite precise, even if it leaves open quite a large range of issues. The status, the limits, the status of the British forces, all this is specified mainly in Annexes A, B, and C to the Establishment Treaty. their legal regime is completed by the British Declaration regarding the administration of the SBAs, which is appended to the treaty, and internally by the British Order in Council made on 3rd of August 1960, together with royal instructions of that same date. But I would suggest that when discussing the BMBCs, we should have a broader approach, since besides the sovereignty, I will discuss a word later, the sovereignty over the territories of the BMBs, the annexes to the Establishment Treaty grant to the UK a variety of rights and facilities regarding, for example, the use of Cyprus roads or ports, or overflight in Cyprus airspace, of the establishment of flights and aids to navigation on the territory of Cyprus outside the bases, notwithstanding the right to use additional, and this, there I quote again, additional small sites as the United Kingdom may consider technically necessary for the efficient use of its bases, areas and installation in the island of Cyprus, end of quote. To be noted, there were at the time 40 such small sites in 1960. I think they have now been reduced to 10, including, if I am right, the radar on Mount Olympus, or the freshwater source at Kisusa in the Limassol district. From my point of view, these ancillary rights are parts and parcels of the global issue raised by the BMBCs. This being said, let me discuss three main questions. First, what is the legal significance of the situation I have just very broadly described? Second, is that situation lawful when assessed in international law terms? Third, whether legal or not, what are the means to put an end or to change that, to put an end to or to change that situation? First then, and still in the sole perspective of international law, how do the BMBCs qualify in international law? As we have just seen, Article 1 of the Establishment Treaty expressly provides that the SBAs, quote, shall remain under the sovereignty of the United Kingdom, and they are expressly named sovereign base areas in Article 2. While in Article 3 of the Treaty of Guarantee, Cyprus and the two other guarantors, quote, undertake to respect the integrity of the areas retained under the United Kingdom's sovereignty, again, sovereignty, end of quote, together with other rights secured to the UK by the Treaty of Establishment. Then, sovereignty. However, things are less clear for two main reasons. In the first place, the treaties themselves, or say more precisely the Treaty of Establishment, limits the British rights to far-reaching rights indeed, nevertheless to limited rights. Generally speaking, the rights belonging to the UK under the treaty are not inherent rights linked with sovereignty and simply recognized by Cyprus. They are functional rights linked with the purpose, the only purpose, of the establishment of the BMBCs, that is, their defense, or more generally, their military object. Without entering into great details, let me list the main limitations. Not only the rights enumerated in Annex B on the small sites are accorded to the United Kingdom by the Republic of Cyprus, this is Article 2.1, but also the duty to cooperate under paragraph 2 of Article 2 is limited to, quote, the security and effective operation of the military bases. And this is so. The bases are military, and the British rise on them are exclusively but for military purposes only. Appendix O of Command Paper 1093 of 1960, which, if I am not mistaken, was the object of an exchange of notes between Cyprus and the UK, and is therefore a binding treaty instrument. By this declaration, in particular, Her Majesty's government, quote, declared that their intention will be, one, not to develop the sovereign base areas for other than military purposes. And the next paragraphs of this provision specify the main consequences of these essential commitments, while Section 3 lists under not less than 19 rubrics the commitments of the UK towards Cyprus and the rights recognized to Cyprus and its citizens in relations with the SVAs and the duty that the Republic is invited, which is not a very legal term, which the Republic is invited to perform in the bases. All these invitations are outside the military sphere. Last but not least, and in fact there are quite a number of other restrictions to the exercise of rights by the UK in and on the basis. It is interesting that Appendix P to Command Paper 1093, also the object of an exchange of notes between the two states, provides for an obligation upon the UK to transfer the SBAs to the Republic of Cyprus in all or in part, quote, in the event that the government of the United Kingdom, in view of changes in their military requirements, very important expression, in view of changes in their military requirement, should at any time decide to divest themselves of the aforesaid sovereignty of effective control, an expression which might deserve some comments if I have more time. But the conclusion, the first conclusion, is already clear enough. The UK cannot be considered as having sovereignty over the BMDCs, according to the celebrated dictum of the Swiss arbitrator Max Huber in the 1928 award in the case of the island of Palmas between the Netherlands and the United States, quote, sovereignty in the relations between states signifies independence. In other words, the administering power does not enjoy sovereignty over the territory of its non-autonomous, no, I am lost, it's not the good paper. Yes, sorry. Sovereignty in, so it's the quote of Max Huber, sovereignty in independence in regard to a portion of the globe is the right to exercise therein to the exclusion of any of the other states, the functions, all functions, of a state. This is usually accepted as stating that the sovereignty of a state has two components, completeness and exclusivity. In other words, a state enjoys on its territory all the competences recognized in international law and has an exclusive right to exercise or to delegate these rights. In the case of the BMDCs, it is indisputable that the UK enjoys exclusive rights, can claim exclusive rights subject to the validity of their establishment, a topic to which I will come next. But as indisputably, the rights in questions are limited, military exclusive, functional. Sovereignty is just inimical to functionalism. Sovereignty is a global concept, implying global rights, unlimited within the framework of international law. That is, subject only to the respect of general norms of international law, whether peremptory or not, or subject to the treaty obligations freely accepted by the state in question, a principle to which I will also come back when I discuss the legality of the BMBs. But for this moment, my problem is not whether or not the British bases are legal, but how they can be defined in international law. And only afterwards, their legality can be seriously assessed. There is a second reason why our bases cannot be legally qualified as being sovereign. You will recall that through Article 1 of the Establishment Treaty, the UK claims to retain sovereignty over the SBAs. The arrears shall remain under the sovereignty of the United Kingdom. Again, the fact that this has been accepted is irrelevant for the moment, although it will of course be relevant to ask later whether Cyprus could accept such a claim. But the question here is different. Could the UK make such a claim? The clear answer to this question is definitely no. To make a long story rather short, since 1925 and until its independence, or 1940, these are subtleties of British law which I don't quite understand, but it doesn't matter. So since 1925 for sure, and until its independence in 1960, Cyprus was a colony of the British Crown. It was treated as such by the United Kingdom, both internally and at the international level. In particular, the British government gave information to the Colonization Committee established under Article 73 of the Charter. And it happens, and this is the important point, that, quote, and I quote one of the most important resolutions of the General Assembly of the UN, that the territory of a colony or other non-self-governing territory has, under the Charter, a status separate and distinct from the territory of the state, administering it, end of quote. In other words, the administering power, the UK in the circumstance, does not enjoy sovereignty over the territories of its non-autonomous territories, British manner to name the colonies. It enjoys rights, territorial as well as personal rights. These rights are extremely extended, but the limits are different and in some respects less extended than those of the administering state on its motherland territory. This is not sovereignty, and I hope that I have made clear that the UK has not and cannot claim sovereignty over the BNBCs. But then, we know what they are not. But what are they? It is commonplace to consider that they are sui generis entities. I have already heard the word. I agree with this in that, to my knowledge, there are no other similar entities in the contemporary world, except maybe with the exception of the US base of Guantanamo, although there are differences, not the least the fact that the UK government declared the European Convention applicable to this territory, and I'm sure that the prisoners in Guantanamo would have enjoyed a comparable gesture by the US. But this sui generis qualification does not help much, Generally speaking, sui generis, sorry, my colleague, sui generis is the unhelpful appellation that lawyers give to situations they cannot put into one of their usual boxes, and law is, first of all, a science, or better, an art of classification. So, it's not... So the bases are neither parts of Great Britain, nor of the Northern Ireland, I would think. They are not. Are they colonies? Does it help to say that they are colonies of the British Crown? I would say yes and no. Yes, in that, I hope we have some time to discuss afterwards. I try to keep the 45 minutes I was allocated. Yes, in that, first, it does coincide to the official status of the BMBs in British law. Dr. Theodorou, in his excellent book, in French, even better, on the military basis in international law, the Cyprus case, cites the chapter on commonwealths and dependencies of the Aylesbury's Laws of England, which explains at section 1047 that the SDAs, quote, consist of those portions of the colony of Cyprus which were not established by the Cyprus Act 1960 as the independent sovereign Republic of Cyprus, and which remain within Her Majesty's sovereignty and jurisdiction. Note, here it's jurisdiction, and I've quoted sometimes to say, and control. They are to be regarded, and this is what is important for us now, as constituting a colony acquired by conquest or cession as from 5th November 1940. Yes, also, it is interesting to say it is a colony in some respect, in that it confirmed that at best, or at worst, the UK cannot claim full sovereignty, and this means sovereignty to court, since sovereignty is full or does not exist. The UK cannot claim sovereignty over the BMBCs. Administrative powers do not enjoy, as I have just said, full sovereignty over their colonies. But on the other hand, the BMBs are very special colonies. This is particularly so because, first, contrary to what they have usually graciously done and still do concerning their other, put it in inverted commas, colonies, the British do not report on the BMBCs to the Decolonization Committee in the UN. And I would think for good reasons. These very specific colonies have no population properly said. Indeed, they are inhabited, but only by two categories of persons: the British military and their families, or Cypriot citizens. And reporting to the UN has been instituted with the view of protecting the population of the territories in question. Both categories of inhabitants of the BMBCs have their natural protector, the UK for their militaries, Cyprus for the Cypriots. And in this respect, and still leaving Guantanamo apart, the only case of a territory without real nationals is, I think, the Vatican, but the comparison does not lead us very far. More generally, it is obvious that in many respects, the British government does not treat the inhabitants of the BMBCs as British citizens or British subjects, whether in matters concerning nationality or taxes or import of goods, etc. And in 2005, the British Court of Appeal, in the case of Saga versus the Ministry of Defence, they are under the control of the Ministry of Defence, not the Commonwealth Office or the Colony Office, Then the Court of Appeal, in that case, went as far as denying that the 1976 Racial Discrimination Act was applicable in the SBAs. In that occasion, Lord Justice Mummery, Justices Tucker and Clark agreeing, restated the usual British position, according to which, quote, acroatírio, but this would hold true for the Kenya as well, of course, is outside Great Britain for the purposes of Part 2 of the 1976 Act. It came into existence as a sovereign-based area as a result of the Cyprus Act and the creation of the Independent Republic of Cyprus. It is a territory of the Crown. It is the territory of the Crown. It has enjoyed the status of British Overseas Territories in the British Overseas Territory Act 2002, having previously been a British dependent territory. That status does not, however, make the sovereign base area part of Great Britain for the purposes of the 1970 Act. End of quote. So, I have no positive explanation to give you. They are not under the sovereignty of the British Crown. They are not real colonies. Is this such a big problem? I think that even these quite negative positions must not make us too pessimistic. We know some things about the BNBs, and I can add some others. First, they are not part of the British territory. Second, seems obvious, but it's important, they are military bases. Although this notion is extremely diverse, this tends to show that even the UK enjoys extremely wide exclusive rights for military purposes only, not others. It does not possess over the bases the global jurisdiction that a sovereign state has on its territory. And let me open a parenthesis here. This is one of the reasons why I do not share the view, widely expressed by Cypriot lawyers, that the BMBCs have no territorial sea. I do think that they have one, and the Republic itself has acknowledged this in many occasions. But the UK can certainly not claim a continental shelf and an exclusive economic zone on behalf of the BMBs. As formally provided for in the UN Convention on the Law of the Sea, which simply and in this regard reflects general international, coastal states only enjoy sovereign economic rights, and the military bases have no economic rights to claim. For the same reason, and more generally, I have strong doubts that the UK could or can take measures which are not related to the main object of the British government when it retained the sovereignty over the areas. And in particular, I would think that in the extremely important paragraph 2 of section 3 of the British Declaration regarding the administration of the SBAs, which provides that, quote, the laws applicable to the Cypriot population on the sovereign basis area will, as far as possible, be the same law as the laws of the, and I am again lost with my papers, this time I'm really lost. Pardon? I'm very sorry. Which page? Yes, sorry. The same as the laws of the Republic. And I think that in this quote, the laws applicable to the separate population on the sovereign basis areas will be as far as possible the same as the laws of the Republic. I think that in this quote, the expression as far as possible must be interpreted legally as meaning as far as is compatible with the exclusively military object of the basis. And this takes me to a last related remark. In the framework of the Annals Plan, the UK committed itself to restore half of the total territory of the BMDCs to the Republic. In this occasion, the spokesman of the Foreign Office declared, quote, "The offered area has no military infrastructure, and therefore this would have no adverse impact on the function or operational capability of British forces," end of quote. I suppose that what was true in 2003 is still true. If it is so, it legitimately raises a question. Is the British presence on these parts of the BMBs, not less than 115 square kilometers, still, is their presence still not only legitimate, but simply legal? The bases have always been explained as necessary for purely military purposes. And this understanding was taken note of in several circumstances during the travaux préparatoires of the Treaty of Establishment. If the basis, or parts of them, are no more necessary or even no more useful to that purpose, the very object and purpose of the British government retaining these areas vanish. I must find the next page. Neither parts of Great Britain nor how positively could I characterize the situation? I would suggest that the BMDCs are parts of the Republic of Cyprus. Parts of the Republic of Cyprus with a very heavy servitude. At the risk of disappointing my colleagues in the audience who are specialists in public international law, I will not enter into the nice legal discussion on whether or not such a thing as servitude exists in international law. Let me just say that I think it does exist without the technicalities characterizing the notion in domestic laws, and that it can be defined as follows, quote, "State servitudes are those exceptional restrictions made by treaty on the territorial supremacy of a state by which a part or the whole of its territory is in a limited way made perpetually to serve a certain purpose or interest of another state." And this clearly takes me to my second question. Don't worry too much, I will be briefer than on the first, but longer than on the third and last question. Such servitude, instituted by a treaty, and in the present case, the treaty which is said to have established the Republic of Cyprus. And I will begin with this very specific question. Since I have noted in my readings on the topic or my discussions with Cypriot friends, colleagues or politicians, that this seems to be a major issue in their mind. It is not. Whatever the official British story can tell, Cyprus has not been established by the Cyprus Act 1960 as the independent sovereign Republic of Cyprus, nor even has it been established by the 1960 so-called Establishment Treaty, not more than Algeria has been established by the change in the French Constitution in 1962, or by the agreement concluded in Evian with the Algerian freedom fighters, contrary to what General de Gaulle maintained at the time. This is not the way states are created in international law. As very aptly explained by the Banenter Commission, Arbitration Commission for the former Yugoslavia, quote, the existence or the disappearance of a state is a question of fact. There are probably few domains where, except pornography, where the maxim, I know it when I see it, is more accurate than when appreciating statehood. A state is established when it exists, when its existence is effective. The only criterion for statehood is effectiveness. To put it otherwise, and to come back to the island of Palma's arbitration that I have quoted some moments ago, if a government exercises durably on a given territory with a given population all the functions of a state, then this entity is a state. There is no question that an independence agreement can deeply facilitate the establishment of the newly sovereign entity. And that is a much more civilized way for creating a state than a war of liberation or secession. But from the point of view of public international law, this is that and only that. The new state, successor state if you wish, is not established by the gracious will of the former territorial state or colonial state, the predecessor state. It is established because it exists, because it performs exclusively, because its government performs exclusively the function of a state on the territory in question. Therefore, and on this I have not the slightest hesitation, the wrongly named Establishment Treaty has established nothing except maybe the BMBs. To this I will come back again. And certainly not the sovereign, independent, both words are synonymous, one is more pedantic than the others. Certainly not the Republic of Cyprus as an independent sovereign state. I do not suggest that independence agreements in general, nor for the moment the 1960 so-called Establishment Treaty in particular, are or is not valid. What I simply say, and again without the shadow of a doubt, is that these kind of agreements never create a state. They can only make its effectiveness possible or reinforce it. And the Nicosia Treaty has not created Cyprus, which is a fact, an effectivity, an effective reality, not more nor less than the Dayton-Paris Agreement has created Bosnia and Herzegovina, for example, or the London Treaty of 1830 has created Belgium. You know how it will be discreted. And of course, this is quite important for our problem. It means that the validity of the Establishment Treaty is of strictly, and I really stress that, is of strictly no importance at all. No importance at all in respect to the existence of the Republic of Cyprus. And this also means that if we were to find that the treaty is not valid, this would be of no consequence at all as far as the very existence and statehood of the Cyprus Republic are concerned. Moreover, but this is more technical and I only mention it in passing, it can be sustained that the provisions of the Establishment Treaty concerning the SBAs are separable from the rest of the treaty. according to Article 44 of the 1969 Convention on the Law of Treaty, which is, I dare say, part of what I would call the constitution of the international society. So, according to this extremely important treaty, 3 conditions must be met for separating one or some provisions from the rest of the treaty. First, the said clauses must be, quote, separable from the remainder of the treaty with regard to their application. And in our case, this is clearly so. The question of the BMBs is clearly distinct from the other obligation accepted by the parties in the treaty. I have no more hesitation to consider that the third condition is met, the continued performance of the remainder, which is not related to the basis, the remainder of the treaty would certainly not be unjust. It might be considered that it would be more just. Things are less evident in respect to the second condition mentioned in Article 44, paragraph 3 of the Vienna Convention, since it might appear that acceptance of the provisions of the SBAs was an essential basis for the consent of the UK to be bound by the treaty as a whole. This, to say the truth, seems to have been the case, even though I have not complete knowledge of the drafting history of the treaty. It seems that in the mind of the British negotiators, this was, from their side, the main element of the global quid pro quo on which their consent was given, and the Cypriot negotiators were quite aware of this. But this leads me to one remark and one further question. The remark is just a reminder. Even if the provisions of the on the BMBCs were seen as non-separable, the termination, even maybe the retroactive termination of the Establishment Treaty would not put into question the independence of Cyprus or the process of succession of states which has been agreed between the parties. Now, the question is, even considering that the SBAs was an inseparable part of the synallagmatic agreement between the parties, was the UK legally entitled to make an agreement on them a condition for granting independence to Cyprus? To have some suspense before trying to answer this question, which I think is the question, let me make a brief excursion in the various motives which may justify the termination or invalidation of a treaty under international law. And as I said before, in this matter, international law is reflected by the 1969 Convention on the Law of Treaties. First, note that according to Article 42 of that Convention, absent a special provision in the treaty itself, the validity of the treaty or of the consent of a state to be bound by a treaty and its termination may only be based on the grounds enumerated in the Convention. I must say virtually all of them seems to have been invoked by Cyprus lawyers or foreign lawyers sympathetic to the invalidity of the 1960 treaty. Honestly, some of these arguments seem to me untenable, to put it politely, and I think it is not a good way of making law to use obviously absurd arguments. This is the case for the putting into doubt of the capacity of the authority of the negotiators to conclude the treaty. With respect, this is rubbish. If it were the case that Archbishop Makarios and Mr. Kuchuk had no capacity to commit the future republic or the republic, then it would mean that no independence agreement could be valid. Freedom fighters can conclude treaties. This is a fortiori the case for a democratic representative of a not yet sovereign entity. I am not much more impressed either by the arguments based on the error of fraud, which are envisaged as ground for the invalidity of the treaty by Articles 48 and 49 of the Vienna Convention. The British side had made no mystery of their intention concerning the BMBs, and the separate negotiators had perfectly understood what it was about. I know that those among you who invoke those grounds against the validity of the treaty have in mind the non-fulfillment of their financial obligations toward the Republic under Appendix R of the treaty by the British. But I have two objections. The first one is that I am not sure that the financial assistance from the UK to Cyprus, which is provided for in this part of the treaty, and I agree that it is part of the treaty, is linked. I don't think that this part is linked with the BNBC. The second one is that in any case, what is at stake here is not a question of error or fraud, but one of breach of the treaty by the United Kingdom. And my considered view is that it is a more respectable ground for terminating this treaty, or parts of the treaty, than the two others, I mean than fraud and error. Article 60 of the Vienna Convention provides that, quote, a material breach of a multilateral treaty by one of the parties entitles a party especially affected by the breach, which would be the case of Cyprus, to invoke it as ground for suspending the operation of the treaty in whole or in part in the relations between itself and the defaulting state, end of quote. Apparently, this would then be only a ground for suspending the 1960 Establishment Treaty. However, I wonder whether in the present case, the treaty should not be treated as if it were bilateral between Cyprus and the UK, since clearly the quid pro quo is between the two of them only. But I have another more serious doubt on this problem of material breach. According to paragraph 3 of that same article, quote, a material breach of a treaty for the purposes of this article consists in the violation of a provision essential to the accomplishment of the object and purpose of the treaty. Honestly, I have some doubt that the violations by the UK of its financial obligations under Appendix R meets this condition. The only position I have on that is that it is arguable, so I'm not sure it is fully convincing. I have the same feeling concerning duress or coercion. According to Article 52 of the Vienna Convention, quote, a treaty is void if its conclusion has been procured by the threat or use of force in violation of the principles of international law embodied in the Charter of the United Nations, end of quote. I think there is no need to insist on the fact that clearly the British side made it either or, buy it or give up bargain. I think there is no doubt that delay for an uncertain future accession to independence and creating a very dangerous situation, the Cypriot negotiators had to buy the bargain. This being said, it is not 100% sure that an international court or tribunal would, for its part, buy the argument. After all international negotiations are based on an unequal balance of power between the negotiators, backed on unequal military, economic, financial, diplomatic, etc. strengths. But what could be added here, and this is for me the main argument, is that in imposing that particular condition, that is, the maintenance or the creation of the BMBCs, the United Kingdom was violating general international. Before coming to that, and I add this for the interpreters, it's not on their paper, just one more ground which I have forgotten, and which is probably the safest one, beside the last one. One of the probably safest grounds to challenging the validity of the Establishment Treaty, and at least of this part of the Establishment Treaty, is probably the existence of a fundamental change of circumstances as embodied in Article 62 of the Vienna Convention. There is little doubt in my mind that even accepting that the BMBCs did correspond to a need in 1960, that they were legal at the time, times have changed, and at least as conceived in the treaty, with this absolute and eternal character, they are anachronistic. And it can be reasonably, I think, said that not the treaty itself, but the BMB's provisions can be terminated on this ground. Now let me come to my last ground, which is, after all, the main one. I suppose that most of you, in this extremely select audience, are familiar with the notion of jus cogens, or peremptory norms of general international law. But after all, being a lawyer is not a peremptory requirement, and nobody's perfect. So let me then just briefly recall that while states are free to reject in a treaty the application of normal customary rules, they cannot adopt provisions which are in contradiction with such peremptory norms. Article 53 of the 1969 Vienna Convention on the Law of Treaties provides, and I quote, "A treaty is void if, at the time of its conclusion, it conflicts with the peremptory norm of general international law. For the purposes of the present convention, a peremptory norm of general international law is a norm accepted and recognized by the international community of states as a whole, as a norm from which no derogation is permitted, and which can be modified only by a subsequent norm of general international law having the same character." While it would take me too much time to elaborate much, but this could be a full topic for another lecture, I think that it can be confidently accepted that all people have a right to self-determination. Concerning more particularly colonial people, this right includes a right to accede to full sovereignty, that is, to statehood. Since Cyprus was a colony in 1960, this confirms and reinforces my argument that the Republic does not hold its independence from the Establishment Treaty, but it was as of right. And this is the most important point for that, what I am discussing now. This accession to full sovereignty must be obtained within the colonial borders before the independence. That is, within the framework of the principle which international lawyers love Latin, which we call iuti possidetis juris principle, which applies in, from my point of view, in all circumstances, whether colonial or not. But these two could be a topic for another lecture. And the colonial power must respect, in any case, must respect the integrity of the territory in question. Quite evidently, the very existence of the BMBCs, as interpreted by the United Kingdom, this is an important precision, is in clear contradiction with these principles. The retaining of the BMBC was made a condition for the accession of Cyprus to independence. And again, independence is as of right for colonial territories. And if it were accepted that the UK has sovereignty over the SDAs, it would be a dismemberment of the territory of the former colony of Cyprus, which is entitled to its territorial integrity. And at least both these elements are incompatible with the principle I have briefly described 1 minute ago. Are they peremptory norms? Today, I have no doubt that they are. The real problem is, were they in 1960? I would think that they were already. The famous General Assembly Resolution for 1514-50, which is called the Charter of Decolonization, was adopted precisely in 1960. It very clearly includes these principles, and I think personally that they were, at the time already, recognized by the international community of states as a whole as norms from which no derogation was permitted. However, I accept that this is debatable. Then suppose I am wrong and that they had not this character at the time. I think that it does not radically change my conclusion. In effect, it happens that besides Article 53, the Vienna Convention contains an Article 64, which provides that, quote, if a new peremptory norm of general international emerges, any existing treaty which is in conflict with that norms becomes void and terminates. Although I do not underestimate some underlying problems, including what lawyers call in their jargon intertemporal law, I think that this provision could apply. This being said, my personal conviction is that the Establishment Treaty is, I would say, contaminated by its original sin, that it has been concluded in violation of existing peremptory principle at the time, in 1960. And that for this reason, it can be considered as null and void. And unfortunately, in such a case, and I say unfortunately, because I think it's too radical a result, unfortunately, in such a case, there is no possibility to apply the system of separability, which is excluded in case of the application of Article 53, while separability works when Article 64 applies. Another important issue is that in several occasions, Cyprus has in fact accepted, again, I must say, the existence of the VMDCs. This certainly creates some legal problems. However, I would tend to consider that if the treaty is contrary in part or in all to peremptory norms, this does not change the conclusion. It is not because you confer obligations and rights which are contrary to peremptory norms that they become more legal. So I would think that even though it is problematic, and I regret that, for you that Cyprus has reconfirmed the basis and called them sovereign basis, my view is that it doesn't change my demonstration, if you agree with it. And I come at last to my third and last question. I will be very brief, don't worry. What can be done? I will be brief since this is less legal than political, and definitely I'm nothing but a lawyer. But lawyers are still, I think, in their role when they expose various possibilities being accepted that then it belongs to the politicians and sometimes directly to the people to decide. There are indeed several options. The first is to do nothing. After all, the situation as it is has lasted for 50 years. It has created a problem, but after all, again, seen at least from abroad, no major drama, and everybody, including the Parliamentary Assembly of the Council of Europe, recognizes that, quote, the British authorities in charge of the administration of the SBAs, by and large, that's true for all states, by and large, treat the local population with respect, end of quote. And I must say that the presence here tonight of the British ambassador and of high authorities from the administration of the MBCs are marks of openness, of care, of concern. Well, now, if things are to move, there are two main options. Either both parties renegotiate the aspects of the Establishment Treaty relating to the MBCs, or Cyprus acts unilaterally. Concerning the renegotiation of the treaty, legally speaking, the main issue is, what about the two other parties? My view is that it is not a major problem. When this is solved, there will be another lecture, when this is solved, there is no problem in the two parties agreeing to some kind of British military basis, not sovereign, but some kind of military basis, on the territory of Cyprus for a limited, but maybe renewable period of time. And such a renegotiation could be the occasion to, which has not been sized by when Cyprus became a member of the European Union, to modernize the rules applicable to the basis, to clarify some aspects, for example, regarding the maritime rights of the British parties, and to fill some gaps. And I would think that a good entry point to negotiations might be proposed, it might be the proposed, then withdrawn offer by the British government to relinquish parts of the BNBs having no more use for military purposes. But again, as a matter of principle, there is no legal objection against accepting some kind of military basis on a sovereign state territory, but not sovereign basis. The other possibility is for Cyprus to act unilaterally. I have, of course, excluded any plan to use force, whatever its form. On a purely legal ground, there are at least two. First, there is a possibility for Cyprus to unilaterally lodge an application before the International Court of Justice on the basis of Article 66 of the Vienna Convention, which provides that, quote, if no solution has been reached by other peaceful means, within a period of 12 months following the date on which the objection was raised, the objection to the application of use covenants, any one of the parties to a dispute concerning the application or the interpretation of Article 53 or 64, these are the provisions of the Vienna Convention on use covenants, any of the parties may, by a written application, submit it to the International Court of Justice for a decision, unless the parties, by common consent, agree to submit the dispute to arbitration. The inconvenience of that solution is that it can only bear upon the conformity of the Establishment Treaty with peremptory norms of general international law. And it is a radical solution, because if the Cyprus case prevails, the result will be that the treaty as a whole will be declared null and void. Second, Article 10b of the Establishment Treaty provides itself for the constitution of an arbitral tribunal to decide, quote, on any question or difficulty as to the interpretation of the treaty. Contrary to what I have read here and there is no possibility for the United Kingdom to refuse such a binding settlement. The real issue is elsewhere. That provision provides that each of the parties to the treaty, and this includes Turkey, may appoint a member to the tribunal. And I suppose that in the present circumstances, it would be difficult, to say the least, for Cyprus to submit itself to an arbitral court comprising a Turkish citizen or even a non-Turkish arbitrator but appointed by your Turkish friends. If this is so, the only possibility would be to negotiate with the UK an alternative means of settlement. I must add that even if the existing provision were to be used, the tribunal, the arbitral tribunals, could only be sized if an agreement cannot be reached by negotiations. But I must say, and it's my last words, I must say that, speaking of negotiations, I'm really surprised that while the Cypriot party seems to be very upset by the issue of the BMDCs, it seems that in reality it has never tried to start negotiation. I might be misinformed, and listening to the first speaker this evening, I see that I am partly, but I have not read the WikiLeaks report of the question, if any. However, I have the feeling that things have come to a point where some kind of bona fide negotiations with a view to coming to a result are necessary. And from my point of view, this result should not be a total rejection of the treaty, since one should not throw the baby with the water of the bath. And I must say that beside the BNDS, I do not see the Establishment Treaty as calling for total repudiation. But I am not sure that lawyers should expose their feelings. We are supposed to expose legal rules and principles, not feelings, and I have better stop. So thank you very much for your time.